Non-public forums from Chapter 9, First Amendment, freedom of expression. D, what places are available for speech. F, non-public forums. Non-public forums are government properties that the government can close to all speech activities. The government may prohibit or restrict speech on non-public forums as long as the regulation is reasonable and viewpoint neutral. The court has found many different types of governmental property to be non-public forums. For example, in Adderley v. Florida, the court held that the government could prohibit speech in areas outside prisons and jails. Civil rights demonstrators held a rally outside a jail after a group of their colleagues had been arrested for engaging in a civil rights protest. The court, in an opinion by Justice Black, upheld the convictions of those protesting at a jail who did not disperse in response to an order from the sheriff. Although the court emphasized the government's security interests, it also spoke very broadly about the government's ability to restrict speech in public places. Justice Black declared, "The state, no less than a private owner of property, has the power to preserve the property under its control for the use to which the law is dedicated. The United States Constitution does not forbid a state to control the use of its own property for its own lawful, non-discriminatory purposes." Justice Douglas wrote for the four dissenters and stressed the importance of the jail as a place for protest. He said, "The jailhouse, like an executive mansion, a legislative chamber, a courthouse, or the state house itself, is one of the seats of government, whether it be the Tower of London, the Bastille, or a small county jail, and when it houses political prisoners for those who many think are unjustly held, it is an obvious center for protest." In Greer v. Spock, the court held that military bases, even parts of bases usually open to the public, are a non-public forum. Although civilians were left free access to non-restricted areas of Fort Dix, a regulation prohibited demonstrators, picketing, sit-ins, protest marches, and political speeches. The Supreme Court held this regulation and said that it is the business of military installation like Fort Dix to train soldiers, not to provide public forum. The court said that governments could exclude such speech to insulate the military from political activities. In United States v. Coquinda, 1990, the court upheld a restriction on solicitations on post office properties. Sidewalks, of course, are the paradigm public forum, but the plurality opinion of Justice O'Connor said that sidewalks on post office property were a non-public forum. The plurality of 4 justices concluded that a postal sidewalk does not have the characteristics of public sidewalks traditionally open to expressive activity. Justice O'Connor said that the postal sidewalk was constructed solely to provide for the passage of individuals engaged in postal business. Although others had been allowed to use the postal property for speaking, leafleting, and picketing, the plurality concluded that this was not enough to transform it into a designated public forum because it did not add up to the dedication of postal property to speech activities. Justice Kennedy, the 5th vote for upholding the regulation, wrote an opinion concurring in the judgment and said that there were strong grounds for applying the standards for public forums, because of a wide array of activities allowed on the sidewalks. Justice Kennedy, however, said that the issue of how to characterize the forum did not need to be resolved because the regulation was a reasonable time, place, and manner restriction. In International Society for Krishna Consciousness, Inc., v. Lee, the court applies these cases in considering whether airports are non-public forums. In International Society for Krishna Consciousness, Inc. v. Lee, and this is a 1992 case. Chief Justice Referred the opinion of the court. In this case, we consider whether an airport terminal operated by a public authority is a public forum and whether a regulation prohibiting solicitation in the interior of an airport terminal violates the First Amendment. The relevant facts in this case are not in dispute. Petitioner, International Society for Krishna Consciousness, ISKCON, is a not-for-profit religious corporation whose members perform a ritual known Sankirtan. The ritual consists of going to public places, disseminating religious literature, and soliciting funds to support the religion. The primary purpose of this ritual is raising funds for the movement. Respondent Walter Lee, now deceased, was the police superintendent of the Port Authority of New York and New Jersey and was charged with enforcing the regulation at issue. The Port Authority has adopted a regulation forbidding within the terminals of the repetitive solicitation of money or distribution of literature. It is uncontested that the solicitation at issue in this case is a form of speech protected under the First Amendment, but it is also well settled that the government need not permit all forms of speech on property that the government need not permit all forms of speech on the property that it owns and controls. Where the government is acting as a proprietor, managing its internal operations rather than acting as lawmaker with the power to regulate or license, its action will not be subjected to the heightened review to which its actions as a lawmaker may be subject. The parties disagree about whether the airport terminals are public fora or non-public fora. They also agree whether the regulation survives reasonableness review governing non-public fora. So I'm going to write these down as issues. And should that prove the appropriate category? Like the Court of Appeals, we conclude that the terminals are non-public fora and that the regulation reasonably limits solicitation. Our recent cases provide guidance on the characteristics of a public forum. We have noted that a traditional public forum is property that has a principal purpose, the free exchange of ideas. Moreover, consistent with the notion that the government, like other property owners, has power to preserve the property under its control for the use to which it is lawfully dedicated. The government does not create a public forum by inaction, nor is a public forum created whenever members of the public are permitted freely to visit a place owned or operated by the government. The decision to create a public forum must be made by intentionally operating a non-traditional forum for public disclosure. Finally, we have recognized that the location of property also has bearing because separation from acknowledged public areas may serve to indicate that the separated property is a special enclave subject to greater restriction. These precedents foreclose the conclusion that airport terminals are public fora. Reflecting the general growth of the air travel industry, airport terminals have only recently achieved their contemporary size and character. But given the lateness with which the modern air travel has made its appearance, it hardly qualifies for the description of having immemorially time out of mind. End quote. Been held in the public trust and used for purposes of expressive activity. So I'm guessing that's the definition. Moreover, even within the rather short history of air transport, it is only in recent years that it has become a common practice for various religious and non-profit organizations to use commercial airports as a forum for the distribution of literature, the solicitation of funds, the proselytizing of new members, and other similar activities. Thus, the tradition of airport activity does not demonstrate that airports have historically been made available for speech activity. Nor can we say that these particular terminals or airport terminals generally have been intentionally opened by their operators to such activity. The frequent and continuing litigation evidencing the operator's objections believes any such claim. In short, there can be no argument that society's time-tested judgment expressed through acquiescence in a continuing practice has resolved the issue in petitioner's favor. Petitioners attempt to circumvent the history and practice governing airport activity by pointing our attention to the variety of speech activity that they claim historically occurred at various transportation nodes such as rail stations, bus stations, wharves, and Ellis Island. The relevant unit for our inquiry is an airport, not transportation nodes generally. When new methods of transportation develop, new methods for accommodating that transportation are also likely to be needed, and with each new step, it therefore will be a new inquiry whether the transportation necessities are compatible with various kinds of expressive activity. To make a category of transportation nodes, therefore, would unjustifiably elide what may prove to be a critical differences of which we would rightfully take account. Although many airports have expanded their function beyond merely contributing to efficient air travel, few have included among their purposes the designation of a forum for solicitation and distribution activities. Thus, we think that neither by tradition nor purpose can the terminals be described as satisfying the standards we have previously set out for identifying public forums. We have no doubt that under the standard the prohibition on solicitation passes muster. We have on many prior occasions noted the disruptive effect that solicitation may have on businesses. The restrictions here challenged, therefore, need only satisfy a requirement of reasonableness. We have no doubt that under this standard the prohibition on solicitation passes muster. Excuse me. We have on many prior occasions. Or is it me, or is this sentence said twice? Because it wasn't me. We have on several prior occasions noted the disruptive effect that solicitation may have on businesses. Cool. The book made an error. Passengers who wish to avoid the solicitor may have to alter their paths, slowing both themselves and those around them. The result is that the normal flow of traffic is impeded. This is especially so in an airport, where air travelers who are often weighed down by may be hurrying to catch a plane or to arrange ground transportation. Delays may be particularly costly in this setting, as a flight missed by only a few minutes can result in hours' worth of subsequent inconvenience. In addition, face-to-face solicitation presents risks of duress that are an appropriate target of regulation. The skillful and unprincipled solicitor can target the most vulnerable, including those accompanying children or those suffering physical impairment and who cannot easily avoid the solicitation. Compounding this problem is the fact that in an airport, the targets of such activity frequently are on tight schedules. This, in turn, makes such visitors unlikely to stop and formally complain to airport authorities. As a result, the airport faces considerable difficulty in achieving its legitimate interest in monitoring solicitation activity to assure the travelers are not interfered with unduly. As a result, we conclude that the solicitation ban is reasonable. So there's a significant amount of post notes here. That I think I'll cover. But the court in Lee also ruled by a 5-4 margin that the prohibition of the distribution of literature in airports was unconstitutional. Justice O'Connor, who voted with the majority in finding that airports are non-public forums and in upholding the ban on solicitation, joined with the 4 dissenters on those issues. To create a majority to overturn the ban on distribution of literature, she concluded that the ban on leafleting was not reasonable and thus was impermissible even though the airport was a non-public forum. Subsequent to International Society for Krishna Consciousness v. Lee, and I think I'll just stop there since this is relating to another case coming afterwards.